Just a second. Will your client waive the formal reading of the indictment?
Sure. Proceed on this.
Ms. Josephine, cause number 24 DCCR 0708 states elected to proceed on the lesser included offense Class A misdemeanor assault from February 20th of 2024. How do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak it, please.
Yes.
And are you pleading guilty because you actually did what they charged you? I have here on the tablet documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, you go over them with Mr. Robinson. Do you fully understand?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached for 18 months deferred probation, there would be a $250 fine. Looks like there's a pending.
Right out of the gate, we're seeing a plea deal in motion. The state is reducing this to a lesser included offense. That's legal speak for we could have gone harder, but we're choosing not to. Why? Weak evidence? Strategic compromise? Or a clean record worth protecting? Keep that in mind, and this is huge. She's waiving her right to appeal. Translation: no takebacks. Once this deal is locked in,
Misdemeanor that this would rank currently with. In addition, you would be required to enter the successfully complete an anger management class, and there would be no contact with Ruthie Duster. Do you understand? And are you a U.S. citizen? State tenders number 1.
No objections.
It's admitted. Is there any evidence that it's just?
Not the money.
All right, ma'am. I'm going to find that you entered the plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of the plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings on probation for 18 months. You're ordered to pay that $250 fine and to follow all of those rules and conditions of probation, including entering and successfully completing the anger management class, as well as having absolutely no contact or communication with Ruthie Duster. It obviously means in person, but it also means sending messages in any way, social media, email, texting, whatever. Do you understand? If you do everything you're supposed to and follow all of the rules and conditions of this probation, this is an excellent opportunity because you don't have a conviction on the record. And at the end of the probation period, if it's successful, the case will actually be dismissed. Never have a conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back to court and you could be found guilty and sentenced to anywhere in the range of punishment, which is 1 year in the Jefferson County Jail. Do you understand? All right, if you'll just, I've handed you the trial court application.
It's locked. That's why judges go line by line like this. They're building a record so no one can later claim, I didn't understand. Smart courtroom insurance policy. Now things escalate. We've shifted from misdemeanor assault to first-degree felony aggravated robbery. That's prison territory. And notice the mention of a co-defendant who recently passed away. That can dramatically reshape leverage in a case.
Shows this wasn't an agreement that I followed, so you did waive your right to appeal. And if you'll just have a seat here in the courtroom, probation will call you up to go over your paperwork in just a few minutes. She's at her desk right up there, so watch her. Thank you. Yes, ma'am.
She's you. It is my intention to follow the case down in the court myself, having met with both of the complainants. Obviously, we would ask that no contact apply to Ms. Roberts as well. That's the associate's daughter. She was also involved in the complainant down the hall. There is a child custody issue, and I would ask this court admonish the defendant that your no contact is specific to each and every aspect of her relationship with him. That has been her mother who's been doing that transfer of the young man. I would ask, that she not be allowed to be on their property whatsoever. And I can get probation about that.
So Ruthie Doster is who?
No.
Okay, and then the other complainant,
Roberts.
Say the name again.
It's Roberts.
Roberts. First name? Do you know what's the first name?
A-U-I-A.
What is it?
Aya.
Oya, how do you spell it? Do you know? And what's the relationship with the Robert?
Nothing. I'm actually in preparation with a lawyer getting my friend back. She's just a guardian.
She's a guardian.
She's a guardian of your son. So that's the relationship. Okay. So I'm going to also order that you not have contact or communication with her except through whatever appropriate means through attorneys or through the family courts. Okay. There's programs you can use, an app where you can use, it's called the Family Wizard app. If she's the guardian, then you've got to follow all of the rules that have to do with that. An attorney don't have any contact or communication unless you have permission to do it in a group basis. Okay? All right. Thank you, Ms. Malfino. Thank you. Have a seat and they'll call you up. Good morning. Are you Jaron Crane?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Judge, the court will recall that this showed to a link apparently a week or so ago. That's some conversation I had with some issues with my case. My understanding is Mr. Crane has been on house arrest pending this plea.
The defense is asking the judge to keep him on house arrest while a pre-sentence investigation is done. That report decides whether
Fewer witnesses, different narratives, new strategy. The stakes just went way up. Let's pause. A guilty plea to a first-degree felony usually carries the possibility of serious prison time. We're talking years, even decades depending on the jurisdiction. So if probation is even on the table, that tells us something negotiated happened behind closed doors. The question is, what did the state get in return? Cooperation? Weak evidence?
Probation even makes sense. This is the court betting on compliance, not punishment. You take that risk?
He remains on such, at least then somebody else suitable.
Okay, thank you. All right, sir. On cause number 23, DCCR 1406, you're charged with the first degree felony offense of aggravated robbery from August 15th of 2023. How do you plead with that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you? Never discovery verification. Have on email. No. All right, sir. In clause number 23, DCCR 2233, you're also charged with the first degree felony offense of aggravated robbery from August 15th of 2023. How do you?
Two aggravated robbery charges. This is where people get surprised. Guilty doesn't automatically mean prison. Deals like this mean prosecutors and defense are aligned. But should a first-degree felony ever end in probation interview 2?
Pleaded that charge. Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you? I have here on the tablet in each of those cases documents that have your signature on them with the state marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rhodes?
Yes, ma'am.
Do you fully understand? And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to it? And it looks like the agreement that you've reached in each of your cases is for a 10-year deferred probation. There would be a
Here's the shocker. 10 years of deferred. This isn't mercy, it's pressure. Complete probation and walk free. Mess up once and everything collapses.
$100 fine in each case. You would be required to follow all of the rules and conditions of probation, and would there be a dismissal in the evading? With your permission, can I write that in?
Yes.
On the plea admonishments. So there would be a dismissal in clause number 23, DCCR 1082, which is the evading. Is that your understanding of the agreement? Do you also understand if you're not a U.S. citizen, plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization? State tenders number 1 in each case. It's admitted in each case. Is there any evidence that Mr. Crane
Colonel.
Alright, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent to understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to restate the cases. The sentencing probation department can do an updated report, give you more information about you, the cases, and kind of what we need to do to make sure that you have all the tools necessary to be successful on probation. So we'll come back later for sentencing. So on your way out of the courtroom today, you need to stop and go to probation. She's at the desk right over there. I am going to leave all the same bond conditions in place that you're under. You've been following all the conditions. You're doing everything that you're supposed to between now and sentencing, so that we won't have any issues when we come back for sentencing. We'll be following these agreements. Okay. All right. We'll see you back in sentencing. Don't forget to stop the